Today I'm looking at, it's page 28 of the 50 that they give you in the agreement. This is the vehicle lease agreement, and it starts on page 28. I want to jump forward, and first let's look at page 30. Excuse me. At page 30, there's some interesting language in section 12. Says use compliance with applicable laws. Leasee agrees to enter into an operating lease agreement during the term of this lease with WEL Companies. Now this lease, this vehicle lease, is between you and Thielen's Leasing Company, or Thielen's Truck Leasing is how they've got it listed. And so you're leasing the truck from Thielen's Truck Leasing, and then you're leasing that truck onto WEL Companies as the carrier. Then WEL Companies is going to take money from you every week to make these payments to Thielen's. So use in compliance with applicable laws, leasee, that's you, agrees to enter into an operating lease agreement during the term of this lease with WEL Companies as the operating carrier for the purposes of providing transportation services in interstate or intrastate commerce pursuant to the Federal Motor Carrier Safety Administration's leasing regulations, 49 CFR Part 376. In the event that the operating lease between the leasee, you, and the operating carrier, WEL Companies, is terminated during the term of this lease with Thielen's Truck Leasing, the leasee shall have the following options. Number one, where all rent payments have been made pursuant to this lease, the leasee may exercise a purchase option contained in paragraph 18 of this lease within 5 days. And that's going to be 5 business days, not 5 calendar days, I would assume. Knowing WEL Companies, probably 5 calendar days, but most companies it's going to be 5 business days. And you can make a very good argument for 5 business days. Paragraph 18 of this lease within 5 days from the date of such termination. Option 2. Leasee may turn in the equipment to Thielen's Truck Leasing immediately, in which case the event of default and Thielen's Truck Leasing remedies provisions specified in paragraphs 14 and 15 respectively shall apply. Or 3. Leasee may transfer the equipment to another operating carrier, pay attention to this, under the following conditions and with Thielen Truck Leasing prior written consent. So you got to get Thielen's Truck Leasing written consent, good luck, to put this on with another carrier. And here's the conditions. New operating carrier has a satisfactory or similar safety rating that enables it to operate without FMCSA intervention or restrictions pertaining to driver, equipment, and other CSA performance measures. An operating ratio for the preceding year was no higher than 98%. And the capability and willingness to deduct the leasee's equipment lease payments, chargebacks, and other deductions, and any other monies owed to leaser under this lease from the leasee's compensation, and remit them to Thielen's Truck Leasing electronically on a weekly basis pursuant to paragraph 1 above. B. Lease supplies Teelan's Truck Leasing for Teelan's Truck Leasing's review a draft of the lessee's planned operating lease agreement with the new operating carrier and include all addendums or attachments, which shall include provisions reflecting compliance with the requirements set forth in paragraph 12. At least 30 days before the lessee signs the operating lease agreement with the new carrier, and C, the lessee agrees to remit to Teelan Truck Leasing the equivalent of 6 months of lease payments, 26 weekly payments, or $15,000 as a security deposit. Lessee shall, let me get to the next page. Lessee shall use the equipment in a careful and proper manner. Lessee shall not use the equipment in violation of any foreign, federal, state, territorial, or municipal law or regulation, and shall be solely responsible for any fines, penalties, or forfeitures. So the gist of this is that if you sever ties with WEL Companies, you can keep the truck and keep your lease agreement with Teelan's Truck Leasing in place, provided that, number one, you sign on with a carrier that they approve of that has a certain CSA score, and number two, you're going to pay them $15,000 in order to move that truck over, and number three, it has to be in your agreement with that new carrier that they're going to withhold those payments that you owe to Teelan's for that truck. They're going to withhold those weekly payments and send them electronically every week to Teelan's Truck Leasing on your behalf. So, good luck with that. Teelan's has to approve the whole thing, and you got to pay a mere $15,000. So, the option is there to keep the truck, keep the vehicle lease in place, and move to a different carrier if you've got $15,000 laying around that you're not using. That's kind of unreasonable in my opinion, but let's go ahead and jump to page 31 and section 15, the event of default, and let's see what they consider an event of default. A, failure of the lessee to pay any rent installment within 5 days of the date upon which the same becomes due. B, any breach or failure of the lessee to observe or perform any of its other obligations under this lease, which shall continue for 5 days after notice in writing to the lessee of the existence of such default. C, abandonment of the equipment. D, dissolution, liquidation, termination of the lessee's business, like your LLC or your C Corp, whatever it is, of the lessee's business, insolvency or failure to pay lessee's debts as they mature in the ordinary course of business, the making of an assignment for the benefit of lessee's creditors, the filing of a voluntary petition for bankruptcy by the lessee, the filing of a petition or answer by the lessee seeking a reorganization arrangement, composition, readjustment, liquidation, or other relief of the same or different kind under any provision of federal bankruptcy laws, or any other provision of federal bankruptcy laws, or any other applicable insolvency law or statute, the lessee's adjudication as bankrupt or insolvent, the appointment of a trustee, receiver, guardian, conservator, or liquidator with respect to all or subsequently all of the lessee's property, the filing of an involuntary petition for bankruptcy against the lessee, or the filing of a petition against the lessee seeking a reorganization arrangement, or other relief of the same or different kind under any provision of the bankruptcy laws. You know, I honestly, reading through this, I think a 7-year-old child wrote this at times, because it's like, well, this and or that, or this and that, or neither this nor that. It's kind of convoluted. And if anyone ever decided to challenge WEL Company on this, I think they'd have some explaining to do, because a lot of this, even in my opinion, even if you take it to your attorney and have them review it beforehand, they're probably going to tell you there's some vague and very convoluted verbiage in here that leaves the door open to interpretation in more ways than one. So just my opinion. Section E, the taking by any party of the equipment or any part thereof upon foreclosure, levy, execution, attachment, or other process of law or equity enforced against the lessee. F, if, in Teelan's Truck Leasing's reasonable opinion, the lessee has neglected, abused, or misused the equipment in any way. So if they don't like the way you're treating the equipment or maintaining the equipment, you know, tough. You know, it sucks to be you. G, and this is the one that's really a kicker in my opinion. If the operating lease agreement between the lessee and the operating lease agreement and the operating carrier is terminated by either party for any reason, and the lessee fails to enter into another operating agreement with new carrier as provided for in paragraph 12. Well, for you to sign on with a new carrier, you have to jump through those other hoops that was explained in paragraph 12. And it has to meet Teelan's Truck Leasing's requirements. And again, this is all in their opinion and in their view. So long and short of it is they got you by the short hairs. Well, sort of. Upon, 16, Teelan's Truck Leasing's remedies. Upon the occurrence of any event of default, the lessee, at the lessee's expense, shall return the equipment to Teelan's Truck Leasing at a point in the United States designated by Teelan's Truck Leasing. The lessee shall have 5 days from the date from the event of default to secure third-party financing to purchase the equipment pursuant to Schedule F, as in Frank, necessary to satisfy all the terms of this lease. At the end of the 5-day period, should the lessee remain in default, Teelan's Truck Leasing may, at Teelan's Truck Leasing option, in addition to any other remedy or right, Teelan's Truck Leasing has hereunder by law, take any and all of the following actions, and then blah, blah, blah. I want to skip on down and go to section 18, because this is relating to your option to purchase. And I want to make sure that everyone has a clear understanding of this. If the leasee is current in leasee's obligations under this lease, then at the end of the lease term, the leasee will have the option to purchase the equipment on the date pursuant to Schedule F, as in Frank. Leasee will have 5 days after the date of any termination of this lease by paying the full amount of all rental payments and any unpaid amounts set forth in this lease, and an additional 4% of the loan balance at any time of such termination. So that's interesting. Leasee will have 5 days from the date of termination of this lease by paying the full amount of all rental payments and any other unpaid amounts set forth in this lease, and an additional 4% of the loan balance at the time of such termination. Unless otherwise provided in this lease, Teelan's Truck Leasing shall be given a minimum 30-day notice that the leasee intends to exercise the option. Upon payment of the purchase price and other amounts owed under this lease, which are non-specified, Teelan's Truck Leasing shall give the leasee all documents necessary to transfer ownership free and clear of all encumbrances, security interest, or liens, and assign any warranties. Teelan's Truck Leasing makes no warranties of any kind, express or implied, in respect to the equipment or leasee's intended use of it, nor any merchantability or fitness for a particular purpose. It will be sold on an as-is basis. If leasee does not exercise the leasee's option, leasee will return the equipment at leasee's option and at leasee's sole expense to Teelan's Truck Leasing office, or to a point Teelan's Truck Leasing designates, or leasee may request extension of the lease. If leasee does not exercise leasee's option, leasee agrees to pay Teelan's Truck Leasing in addition to any amounts owed by the leasee to Teelan's Truck an administrative fee listed in Schedule A, which may be satisfied by Teelan's Truck Leasing from amounts in the reserve fund described in paragraph 7 and Schedule C. And we'll get to F, A, and C in other videos. But I wanted to go through and let you know that, number one, there is an option, if you want to call it that, to take the truck from WEL and move it to another carrier like Landstar or Prime or whomever, provided that you pay that $15,000 fee and you get Teelan's Truck Leasing approval. And I think that's going to be the caveat right there. I'd make damn sure I got their approval before I paid any $15,000. And they're giving you a limited amount of time here, so you would need to have your ducks in a row with another carrier before you started moving in that direction. So again, just be aware what your options are, what your obligations are, because these guys are trying to be slick, but they're trying to be slick, but in my opinion, they ain't smart enough to know how to be slick, because whoever the lawyer is that wrote this, my, just my opinion, but I've seen better from law school students. Anyway, that's my little tidbit of insight for today. You guys, please take your time. Do not allow WEL Companies or anyone else to rush you into signing something. Take your time. Whenever you're comfortable with your knowledge and understanding of what they're trying to get you to sign, when you've had time to review it with your attorney, with your legal counsel, then and only then would I say sign. You have to protect you, because at the end of the day, ain't no damn body looking out for you but you. All right? You guys take care, and I'll see you next time. Bye.